Hi, everybody. I'm Professor Leong, and today I'm going to talk about 5 approaches to a law school paper, or 5 types of legal scholarship that you can produce very successfully as a law student or as a new author. This expands on a topic that I mentioned briefly on a video I released previously, in which I outlined a 10-step process for writing a law school seminar paper or a law school law review student note. And I'll link to that video below this one. Today, what I want to do is elaborate on these 5 different approaches that you can take to writing about a topic that you're interested in. Let me start by saying a few words about what I'm going to call the typical approach to scholarship as a law student. So what many law school seminar papers and law review notes do is identify some sort of legal problem, like a disagreement among the appellate courts, a new issue where there's not necessarily a circuit split yet, but the courts haven't developed an approach, a piece of legislation, and the question of whether it's constitutional, something like that. And so the typical paper, identifies this problem, describes it, explains the legal arguments and what other people have said about it, and then makes an argument for how it should be resolved. Now, let me be clear. This is a great approach, and it's one that I've used many times myself. But it's also not the only approach. It's just, I think, the most common. And so I want to do, what I want to do in this video is briefly describe 5 other approaches to a topic that you're interested in and give you some examples from my own work and from student work that I've supervised. All 5 of these approaches can be successfully adopted by any law student. You don't need any specific kind of background or training. Anybody can do any of these. One interesting approach to a particular topic can be to read all of the cases that fit certain criteria, code them according to some piece of information that interests you, and then just see where the data take you. So let me give you 2 examples. The first example is a paper I wrote myself several years ago, in which I was interested in seeing how courts resolved Fourth Amendment issues differently when they were litigated in criminal proceedings as opposed to civil proceedings. So I read every published federal appellate case over a 5-year period that resolved one or more Fourth Amendment issues, which ended up being about 1,300 cases. I was younger and more energetic then. And then I coded each case for several things: what type of Fourth Amendment issue it presented, who won, and so on. And what I ended up with was a lot of information, and I was able to draw some really interesting conclusions and contrasts about the way that courts approach the Fourth Amendment differently depending on whether a particular issue is litigated in a criminal case or a civil case. That paper is called Making Rights. It was published in the Boston University Law Review in 2012, and I will link it down below this video along with all of the other published work that I'm going to discuss. The second example is a great research paper that a student who I supervised recently wrote, in which the student looked at a few years of appellate decisions in which a court decided whether a confession was voluntary within the meaning of the Fifth Amendment. And then the student author coded these cases for whether the person who ended up confessing received Miranda warnings orally, in writing, or not at all. And I won't give away the conclusion because I think the student intends to publish their paper, but there were some really interesting contrasts along the lines of whether or not there was a warning and what type of warning it was. And so just looking at a set of cases can provide really interesting information about what courts are actually doing. Now, the downside is that reading and coding the cases can take a while depending on how many you look at, but the payoff is that you're discovering something new. And what I found, at least, is that coding cases and creating a data set like this creates a situation in which once you're done, once you have the information, the paper writes itself very quickly. Another interesting approach is to look at the similarities and differences in how different states approach a particular legal issue. And one way to do this is to look up the relevant laws relating to a given legal issue in all 50 states. 50 state surveys can be really great projects for law students who are writing a paper or writing a law review note, because legal scholarship in general is very focused on federal law, and in particular the Supreme Court. In my opinion, this is a bad thing, but that's a topic for another video. The broader point is that 50 state surveys can provide a sense of where the country is on a particular issue. So are state legislatures getting out in front of social opinion, or are they lagging behind? Are there a lot of outdated laws on the books that don't make sense in today's world? Let me give you an example of this type of scholarship. About 5 years ago, I wrote an article with one of my students about state cyber harassment laws. So we looked at the cyber harassment, cyber stalking, and cyber bullying laws in all 50 states. Different states kind of categorize them differently. But so we looked for those laws in all 50 states and grouped them into one of a few different categories depending on the characteristics of the law. Now, I'm not going to take you through the whole paper, but one of the things we were able to do was to show that the language in a lot of the laws was completely out of date. Like some of the laws didn't even contemplate that email existed. And so then we looked at the case law in the states with the most outdated statutes and suggested that in some instances, these decisions were not well reasoned because these outdated laws and the language in them weren't actually providing judges with guidance that would address new and more sophisticated technology. Now, both technology and law have evolved quite a bit since we published this paper 5 years ago, so our paper is already a little bit out of date. But in the meantime, it was cited by a few courts that found that having this sense of the big picture was useful in terms of figuring out how their own state's laws fit in. One really valuable contribution that a student note can make is to provide information about how lawyers approach practical problems in the real world. So, for example, how do lawyers who specialize in a particular area deal with an issue that comes up in their practice, whether it's a substantive legal issue, maybe a client counseling issue, an ethical issue, or one of many other possibilities? Let me give you an example from something that I wrote while I was still a law student myself. I wrote this paper for my legal ethics class, and I was interested in looking at how attorney-client privilege works when the client is a government entity. Now, there's plenty to say about this doctrinally, but I was also just interested in how practicing attorneys who represent government clients actually think about this issue. So I interviewed 30 attorneys who represented various governmental entities, mostly state agencies, but also some municipalities, and asked them how they thought about attorney-client privilege. And this was fascinating, even just the answer that they gave to the question of who is your client when you represent a government entity, who's the actual client, differed widely. It ranged from the head of the agency to the agency itself to, in some cases, the general public. So qualitative information like this can be really valuable because it can make an abstract doctrinal dispute concrete. It can help clarify what the stakes are in thinking about many different kinds of problems, and it can help people who don't practice in a particular area understand how lawyers who do are dealing with a particular issue on the ground. I'll also just add that interviews are really fun to do, and they're a potentially great networking opportunity if you choose your topic well. One word of caution. Anytime that you do research involving human subjects, your institution may require you to get approval from some sort of internal entity, often called an IRB or internal review board. This is a little bit different at every school, so I'll just flag the issue. And if this is something you might be interested in doing, talk to your professor or to whoever's supervising your law review note about this particular issue. One of the most informative contributions that you can make as an author who is still a student is to collect some concrete factual information about the world that nobody else has yet. Now that's a little bit vague, so let me give a specific example. In 2013, I co-wrote an article with a different student of mine about how police officers use consent forms in the context of searches. And the upshot is that even if the police don't have probable cause for a search, if the person who is being searched consents voluntarily to the search, then that search doesn't create a Fourth Amendment problem. There's no Fourth Amendment violation. And so what we were interested in is whether police departments were obtaining consent orally or in writing, and if they were using a written form, what did that form actually look like? So we tried to contact the state police department in all 50 states. I think we ended up getting about 38 out of 50, which by the time we did this, we were pretty proud of ourselves. It was pretty hard. But again, this information is now somewhat outdated, but we learned all kinds of things just by collecting the forms and looking at what they said. So for example, some of them said things that didn't really map onto Fourth Amendment doctrine. Others were actually more informative than they needed to be under the Fourth Amendment. And so gathering primary information like this about the world can be a really useful contribution, because we wouldn't know this otherwise, and we collected it and we put it all in one place. So it's one thing for somebody to write a paper about written consent forms, and another to actually help readers understand what these forms look like and maybe why they're a problem, or maybe how they could be made better. As a side note, my student co-author for this paper is now a public defender. She's very successful, and she's mentioned that one of the things she had the opportunity to talk about in her interview was this research. Finally, one thing that you can write about in a student paper is your own experience. This can be incredibly valuable. And let me just say, this could mean a lot of different things. It could mean other areas of expertise. Well, let's say that you have a background in linguistics. Maybe you want to analyze something like why judges sometimes write in the first person and sometimes why they write in the third person. I've been interested in this for a while now, and I don't know if I know the answer. Or it could just mean your current experience right now as a law student, right? That's experience that you have that most of your readers don't. I mean, I think there are lots of things that members of the legal profession would care about if they knew about them. And you know about them because you're a law student. And sometimes the reason that members of the legal profession don't know more about something is just because they're not law students, and no law students have written about this. So a few examples might be, one that's really current right now is what it is like to take the bar exam in the time of COVID-19. You could also talk more generally about the law school experience and various aspects of it. What function the Socratic method has in a contemporary law school classroom, or what it's like to attend a law school that's not very diverse in a way that is important to you. Maybe what it's like to sit in a Zoom classroom. I know a lot of professors would really appreciate that perspective right now. My point is really just that I can guarantee that every one of you has expertise in something, whether it is something that's pretty closely related to the law, or maybe something that's a little further afield, like a hobby or a pastime. I can guarantee that every single one of you is an expert in something that I know nothing about, and maybe that no law professor knows anything about. And that kind of expertise can often be a great jumping off point for writing a paper that you're really excited about. Okay, so I hope that this video has been helpful to you. Again, this is part of a series of short videos about law student writing that I will be posting over the next few weeks. If you'd like to get notifications whenever I post a new video, go ahead and hit subscribe. And if you have questions, please feel free to contact me. My information, all the ways to get in touch with me are below the video. Thank you so much for watching.